Most jury verdicts take about 12 to 15 minutes to read, because most indictments don't require the clerk to say the word guilty over and over like a metronome. But at 4:09 in the afternoon, inside a federal courtroom that had been running on adrenaline for 6 straight weeks, a verdict was read in 3 minutes and 41 seconds. And I'm telling you, after spending 3 decades inside this system, when a verdict reads that fast, it's not because the jury got bored. It's because the jury wasn't debating. They were confirming what the evidence already made obvious. The defendant in this case, let's call him Evan, was 58 years old, well-dressed, controlled posture. The kind of man who learned, long ago, to keep his face neutral when people are watching. He built a chain of outpatient clinics across 3 states. Legitimate patients, legitimate services, at least on the surface. But the indictment said the surface was the whole point. Underneath, prosecutors alleged he had built something else entirely, a billing engine designed to print money off inflated codes, unnecessary testing, and kickback-driven referrals. The grand jury charged him with 19 counts: healthcare fraud under 18 U.S.C. CC 1347, wire fraud under 18 U.S.C. CC New 1343, conspiracy under 18 U.S.C. CCC New C Testy, U.S.C. CS 1371, and money laundering under 18 U.S.C. CC 1956. Then, almost as an afterthought in the early filings, but it became the center of gravity at trial obstruction counts under 18 U.S.C. 71519 and witness-tampering allegations under 18 U.S.C. 71512. The number the government repeated, again and again, wasn't just a loss figure. It was a moral argument. $86.4 million. The amount the government said was fraudulently billed and paid out through federal programs and private insurers across a 6-year period. And here's how these cases usually go. The defense tries to turn fraud into complicated medicine. They try to turn intentional conduct into administrative chaos. They try to make the jury feel like it's punishing innovation. That strategy can work when the evidence is fuzzy. But the evidence in this case wasn't fuzzy. It was documented. It was logged. And this is the part that ends cases. It was explained by insiders. Because the prosecution didn't build this case on one angry former employee, they built it like a triangle. 3 corners, each one pointing to the same conclusion. Corner 1, the paper. Billing spreadsheets, coding patterns, internal audit emails, and compliance reports that warned, explicitly, that the clinic's numbers were statistically impossible compared to peer facilities. Corner 2, the money. A flow of payments, consulting fees, marketing agreements, education grants that went out to referral sources and came back as patients. A quiet loop that looked respectable on paper until you lined up the dates. Corner 3, the voice. Recorded calls. Not dramatic threats, not screaming, calm instructions. The kind of calm that only exists when someone thinks they're untouchable. The verdict day began like every verdict day begins. Quiet, tense, artificial politeness. Defense counsel speaking softly. Prosecutors sitting unusually still. The defendant acting like he'd already decided how he wanted to be remembered. Evan actually smiled when he walked in, not a grin for the jury. The jury wasn't there yet. A smile for his family in the gallery, like a reassurance, like a message. We're fine. Then the jury filed in, and the 4-person stood. This is where people who have never been in a courtroom misunderstand what's happening. The dramatic moment isn't just the word guilty. The dramatic moment is what happens to someone's nervous system as the story they've told themselves collides with a single syllable. The clerk read count 1, guilty, count 2, guilty, count 3, guilty. Evan's smile didn't disappear immediately. It froze in place, like his face was waiting for the next line to contradict what it just heard. Count 4, guilty. Count 4, guilty. Guilty. By count 6, his eyes weren't moving the way eyes move when someone is listening. He wasn't processing, he was enduring. Count 7, money laundering. Guilty. That's when his right hand, which had been resting flat on the defense table, tightened into a fist. Slow, quiet, like his body was trying to hold on to something solid. Count 8. Guilty. Count 9. Guilty. And then the clerk reached the first obstruction count. Now, obstruction is different in the mind of a jury. Fraud can be argued. Fraud can be debated. Fraud has gray areas that defense lawyers love. Obstruction does not feel gray to jurors. Obstruction feels like cheating the process. The clerk read it. Guilty. That was the moment Evan's posture changed. His shoulders dropped about half an inch, not like someone slumping from sadness, like someone losing internal structural support. He blinked slowly, twice, and looked down at the table as if the wood grain could offer an alternative reality. Count 11, guilty. Count 12, guilty. By count 13, his attorney had stopped taking notes. That's another quiet tell that people miss. When the defense stops writing during a verdict, it means they're no longer managing details, they're managing damage. Count 14, guilty. Count 15, guilty. Count 16, guilty. Evan's breathing became visibly shallow, not theatrical, not performative, just shortened. That quick, chest-only breathing that shows up when a person's brain starts calculating something it can't emotionally digest. Count 17, guilty. Count 18, guilty. And then count 19, the final count. Guilty. 19 out of 19. A perfect conviction record is rare, not because defendants are often innocent, because juries often compromise. They'll acquit on one count to prove to themselves they weren't swept up. They'll split a verdict to preserve the feeling of balance. A clean sweep means the jury found no foothold for doubt anywhere. And for a defendant, that isn't just a loss. That's a collapse of options. Here's what happened next, and this is where the case truly turned. The judge thanked the jury, dismissed them, and then turned to the parties to schedule sentencing, standard procedure. But the prosecutor stood and said, "Your Honor, the United States moves for immediate detention pending sentencing." That's when the air changed again. Because it's one thing to lose and go home on bond waiting for sentencing. It's another thing to lose and have the government argue you shouldn't leave the building. The legal standard for detention pending sentencing is different than pretrial release. Under federal law, once you've been convicted, the presumption flips. The court considers flight risk and danger. But now, with a new reality, the defendant is no longer merely accused, he's convicted. And in Evan's case, the government argued two things. First, the sentencing exposure was enormous. Loss amount, number of victims, sophisticated means, leadership role, money laundering. That combination can create a guideline range that feels like a life sentence to a man in his late 50s. Second, the obstruction conviction wasn't just a count on paper. It was proof of behavior. The prosecutor didn't say, "We're worried he'll run." She said, "He has already shown he will interfere." That's not paranoia, that's logic. Because here's what the obstruction evidence actually was. During trial, the government introduced an email chain from Evan to his operations director with a simple instruction: purge anything that references the code push. The code push was internal language for a billing guideline change they implemented after insurers began questioning their numbers. The government's theory was that they didn't change behavior to comply. They changed behavior to hide. Then came the testimony of the former compliance manager, call her Hannah, who was subpoenaed with a stack of internal reports. Hannah told the jury she warned Evan explicitly that their billing patterns were outside normal medicine and that insurers would see it as fraud. She testified that Evan's response wasn't confusion, it was irritation. And then she described a meeting, one sentence, that the jury didn't forget. She said Evan looked at her and said, "Your job is to keep us safe, not to slow us down." That sentence is not illegal by itself. But when you pair it with the spreadsheets, the money flow, and the patient volume anomalies, it becomes a window. Then the government introduced the recorded call. Evan speaking to a clinic manager who had been contacted by investigators. Evan's voice was calm, not angry, not desperate. He said, in substance, "If they ask about the testing, say it was standard. Don't start explaining. And don't say you talked to anyone else." That's not coaching someone to tell the truth. That's coaching someone to control the narrative. So when the prosecutor asked for detention pending sentencing, the judge had to decide whether Evan would respect the process, now that the process had finally delivered consequences. The defense attorney stood and made the arguments you'd expect. No violent history, deep community ties, medical issues, family. The business employs hundreds. He'll surrender his passport. He'll accept home confinement. And the judge listened, because federal judges do listen. They don't treat detention like a trophy. But then she asked one question, one of those questions that's less about the answer than the truth hiding behind it. "Counsel," she said, "given the obstruction verdict, why should I believe he will comply with any condition that relies on his honesty?" That's the key point. Conditions work only if a defendant respects them. And for a man convicted of fraud and obstruction, the court is not looking at your resume. The court is looking at your pattern. The prosecutor then requested permission to make a brief proffer about something that hadn't been presented to the jury because it was tied to post-indictment conduct. The judge allowed it, and the prosecutor explained that after discovery began, Evan had used a third party to contact a billing contractor and request duplicate copies of deleted records, records the subpoena demanded, not to produce them, to see what the government might find. That's not defense preparation, that's reconnaissance. The defense objected. The judge noted the objection. Then she ruled. Her tone didn't change, her volume didn't rise. That's what makes these moments so devastating. The system isn't emotional when it closes the door, it's procedural. I find, she said, that detention pending sentencing is warranted based on the nature of the offenses, the obstruction conviction, and the defendant's demonstrated willingness to interfere with the process. Then she said the words Evan's body had been trying not to hear all morning, "Mr. W., you will be remanded." And Evan, who had maintained control through an indictment, through discovery, through trial, through weeks of testimony, did something small that told you everything. He whispered, "No," under his breath. Not a speech, not a plea, just a reflex. A marshal stepped forward, calm, professional, practiced. Evan didn't resist, he didn't lunge, he didn't collapse, he simply stopped moving, like his body had decided motion was pointless. The handcuffs came out. And the sound was the same sound I've heard echo in courtrooms for decades, a soft metallic click that feels louder than it should because everyone in the room understands what it represents. Now let me explain why this matters legally, because the verdict is not the end of this story. In federal court, the verdict is the beginning of the numbers. Sentencing in a case like this is arithmetic dressed up as morality. The guidelines calculate base offense levels, enhancements, and adjustments. Loss amount pushes the number up. Number of victims pushes it up. Sophisticated means pushes it up. Leadership role pushes it up. Leadership role pushes it up. Money laundering pushes it up. Obstruction pushes it up again. And then, once you've built that mountain, the judge considers the statutory factors, deterrence, respect for the law, protection of the public, the nature and circumstances of the offense. Here's the mistake the public often makes with white-collar crime. They think the harm is abstract. They think it's numbers on a ledger. But in healthcare fraud, the harm isn't just money. It's trust. It's the integrity of a system that's supposed to exist for people who are sick, vulnerable, desperate. And juries feel that. That's why they convict so cleanly when the evidence is strong. Now, will Evan appeal? Of course, everyone appeals. But here's the reality. Appeals don't retry cases. They don't reweigh credibility. They don't re-listen to the recorded calls and decide they would have heard them differently. An appeal is about legal error. Jury instructions, evidentiary rulings, sufficiency of the evidence. And when you have emails, spreadsheets, insider testimony, and recorded statements, when you have a case built on multiple independent pillars, appeals become hard, not impossible, hard. And even if you win a sentencing argument, shave off a few levels here, challenge an enhancement there, you're still left with a core fact that doesn't go away. A jury looked at 19 counts and found guilt on all 19. That is the system functioning as designed. So let me ask you something, because I genuinely want to hear how you read this. When a defendant is convicted of fraud and obstruction, should judges remand immediately pending sentencing, or should they still try restrictive conditions first, home confinement, GPS monitoring, third-party custodians? Drop your thoughts in the comments. If you want coverage that follows evidence in court procedure, not social media spin, subscribe, like, and share. And tell me, when you watched the word guilty get repeated 19 times, at what count do you think Evan realized the story he'd built was finally over?